to the 34th lecture of this lecture series on International Arbitration Practice. This lecture is a part of Chapter 2 on Invoking Arbitration in International Commercial Arbitrations and in International Investment Arbitrations. In the past 10 lectures, we dealt in detail with invoking ICSID arbitration and also provided a checklist which could be used for drafting or vetting an ICSID arbitration. In this lecture, we deal with invoking non-ICSID arbitration under an investment treaty using a checklist. For your convenience, the checklist has been prepared and can be downloaded from the description to this video. Unlike in invoking arbitration under the ICSID, we will not deal with each and every item of the checklist because most of the items are virtually the same. There are a few items that are different and we will see examples of those items which are different. These include the introduction and the jurisdiction parts. For explaining practically how these items are dealt with in the notices, we take the help of actual disputes such as Nord Stream 2 AG versus the European Union. The first item in the checklist is the notice or request to arbitration invoked under the relevant applicable rules such as the unsettled arbitration rules pursuant to the relevant provision in the investment treaty. The first item is dealt with under the Energy Charter Treaty as follows. 1. Nord Stream 2 AG, the claimant, or NSP 2 AG, a company incorporated in Switzerland, hereby serves this notice of arbitration, the notice, on the European Union, the respondent, or the EU, in accordance with Article 3 of the Arbitration Rules of the United Nations Commission on International Trade Law 1976, the Unsettled Rules, and Article 26, 4b of the Energy Charter Treaty, the ECT. As previously stated, most items in the checklist are similar to the one relating to ICSID arbitration, but non-ICSID arbitrations have distinct jurisdictional requirements. In that, they have to only meet such requirements in the investment treaty, such as the bilateral investment treaty or the energy charter treaty, whereas in ICSID jurisdiction, they have to satisfy the jurisdictional requirements of the treaty as well as those of the ICSID. This is known as the double barrel test or the double keyhole test. Item 26 is the declaration that claim fulfills each of the jurisdictional requirements under the investment treaty. In the Nord Stream notice, this is dealt with as follows. 12. For the following reasons, the claimant's claim set out in this notice fulfills each of the jurisdictional requirements under the ECT. Hence, the claimant's investments in the EU are protected by the ECT. 13. The substantive protections set out in the ECT apply to investments of investors of one contracting party in the area of the other contracting party. The next item is that the claimant is an investor for the purposes of the investment treaty. The Nord Stream notice states in this regard. 15. Article 1(7) of the ECT provides that investor means A. with respect to a contracting party, 2. a company or other organization organized in accordance with the law applicable in that contracting party. 16. NSP 2 AG is a company constituted under the law of Switzerland, and NSP 2 AG is therefore a Swiss investor for the purposes of the ECT. Item 28 is the requirement there is an investment. The Nord Stream notice discusses this requirement in great detail and we quote this for your convenience. 18. The definition of investment in Article 1(6) is a broad one, of which the subparagraphs are only examples. The claimant's investments in the EU fall squarely within both the broad general definition and specific examples. As regards the latter and without limitation, the claimant's investments include the following. 1. The claimant owns, has constructed and will operate the whole of the Nord Stream 2 pipeline, including the section in German territorial waters and the landfall facilities. This constitutes tangible property within Article 1(6)(a). 2. The land purchased by the claimant in Germany where the pipeline makes landfall, which constitutes property and property rights within Article 16A. 3. The claimant's contracts with various EU companies for the performance of services or provision of materials connected with the construction and operation of Nord Stream 2, which constitute claims to performance pursuant to contract having an economic value and associated with an investment within Article 16C. And 4. The permits obtained by the claimant from Finland, Sweden and Germany to authorize the construction and or operation of the Nord Stream 2 in those areas, which constitute a right conferred by virtue of licenses and permits granted pursuant to law to undertake any economic activity in the energy sector within 16F. 19. The claimant has therefore made qualifying investments for the purpose of the ECT. To illustrate this point at the most simple level, the claimant exhibits to this notice of arbitration a photograph of its installations in Germany where the pipeline makes landfall within the EU. 20. The claimant reserves the right to amend or supplement this description and categorization of its investments. The next item is that the investment is covered within the scope of the investment treaty. In the context of the Energy Charter Treaty, it has to be established that Article 1.6 read with Article 1.5 that the investment should pertain to an economic activity in the energy sector. Article 1.6 of the ECT reads, investment refers to any investment associated with an economic activity in the energy sector and to investments or classes of investments designated by a contracting party in its area as charter efficiency projects and so notified to the Secretariat. Article 1.5. Economic activity in the energy sector means an economic activity concerning the exploration, extraction, refining, production, storage, land transport, transmission, distribution, trade, marketing or sale of energy materials and products except those included in Annexure NI or concerning the distribution of heat to multiple premises. The Nord Stream notice seeks to establish how the investment concerned in that relates to an economic activity in the energy sector. It says 24. Therefore, any investment associated with the exploration, extraction, refining, production, storage, land transport, transmission, distribution, trade, marketing or sale of natural gas satisfies this definition. The claimant's investments as outlined in paragraph 18 above are all associated with the transmission, distribution, trade, marketing and sale of natural gas through the construction and operation of Nord Stream 2, which will transmit natural gas from Russia to Germany. Item 30 is the investment is within the host state or area covered. The Nord Stream notice states in this regard 27. The claimant has made investments in the area of the EU, including without limitation the construction of Nord Stream 2 in the German territorial sea and the landfall facilities, the purchase of land in Germany for this purpose, the conclusions of contracts with EU companies, the obtaining of permits from Finland, Sweden and Germany to authorize the operation of the Nord Stream 2 in these areas, and other commercial activities and investments associated with these investments. So, these are the differentiating points between a notice of arbitration under the ICSID and the non-ICSID notice. That's all in this lecture. See you in the next one. Bye bye and stay safe.